So I welcome everyone to today's hearing on legislative proposals to strengthen the Voting Rights Act, and I will recognize myself for an opening statement. Today's hearing on legislative proposals to strengthen the Voting Rights Act is part of a series of hearings that the House Judiciary Subcommittee on the Constitution, Civil Rights, Civil Liberties is holding this Congress to assess ways we can once again give effect to the preclearance requirement of Section 5 of the Voting Rights Act of 1965. The Supreme Court effectively gutted that requirement in Shelby County versus Holder when it struck down the coverage formula to determine which jurisdictions would be subject to preclearance. As a result, the preclearance provision remains dormant unless and until Congress adopts a new coverage formula. Our focus of today's hearing is on proposals that would create a new coverage formula, as the Supreme Court invited Congress to do so in the Shelby decision. It would also strengthen the Voting Rights Act in other ways. H.R. 4, introduced by Representative Terry Sewell of Alabama, would, among other things, establish a coverage formula that would cover states where 15 or more voting rights violations have occurred over the previous 25 years, or where 10 or more violations occurred if at least one of those violations was committed by the state itself. A political subdivision would be covered if it committed 3 or more violations within the previous 25 years. A jurisdiction would be covered for a maximum of 20 years. Similarly, H.R. 1799, introduced by Representative Sensenbrenner of Wisconsin, would, among other things, establish a coverage formula, although this bill proposes a shorter 15-year look-back period and cover jurisdictions with fewer violations over that shorter look-back period. The right to vote is the right that guarantees all other rights in our democracy. Unfortunately, the right of African Americans and other members of racial and language minorities to vote has been threatened and undermined throughout our nation's history. The Voting Rights Act, with an effective preclearance provision, went a long way towards righting that wrong. But sadly, since the effective neutering of the preclearance provision, voting rights for minorities once again is under sustained assault in many parts of this country. We've gathered substantial evidence over the course of 6 prior hearings before the subcommittee, as well as in one hearing before the full House Judiciary Committee, and hearings before other committees that has resulted in a detailed record of voter suppression efforts by states and localities and the effective absence of preclearance since the Shelby County decision. North Carolina, for example, passed a sweeping voter suppression law that a federal appeals court ultimately held to be unconstitutional, finding that it unintentionally, quote, targeted African Americans with almost surgical precision. We also heard about recent measures to make it difficult or impossible for minority voters to exercise their right to vote. These measures include polling, place closures and relocations, the purging of voter rolls that disproportionately target racial and ethnic minority voters, discriminatory photo ID laws, and restrictions on ex-felon voting, all of which are designed to make it harder for African Americans and other racial and ethnic minorities to vote. To the extent that these measures have historically been used to suppress the voting rights of racial and ethnic minorities, it is worth considering whether Congress should adopt a practice-based preclearance regime in addition to a geographic coverage formula. Last month in Memphis, we learned about Tennessee's third-party registration law that would impose draconian penalties on groups like the League of Women Voters, who work to register new voters for minor errors and omissions in registration forms. This law was the subject of a successful legal challenge. Back in May, we learned about a similar law in Texas and about many other examples of voter discrimination in that state, and we've seen states engage in racial gerrymandering designed to dilute the strength of minority voters. The Voting Rights Act preclearance provision required certain jurisdictions with a history of voting discrimination against racial and language minority groups, those predominantly, though not exclusively, in the Deep South, to obtain approval of any changes to their voting laws or procedures from the Department of Justice or the U.S. District Court for the District of Columbia before that change could take effect. This mechanism ensured that new voting rules and practices in jurisdictions with a history of discrimination were fair to all voters. It rightly prevented potentially discriminatory voting practices from taking effect before they could harm minority voters. And in this way, preclearance proved to be a significant means of protection of minority voting rights. This is why Congress had repeatedly reauthorized the preclearance provision on an overwhelmingly bipartisan basis, most recently in 2006 when the House passed the Voting Rights Act reauthorization by a vote of 390 to 33, and the Senate by 98 to 0 vote, a result due in no small part to the substantial efforts of then House Judiciary Committee Chairman James Sensenbrenner. In the absence of an effective preclearance regime, it is unsurprising that discriminatory measures have and will continue to undermine the voting rights of racial and language minority voters and erode our democracy. While Section 2 of the Voting Rights Act, which prohibits discrimination in voting, remains in effect, it is by itself a less effective, significantly more cumbersome, and often prohibitively expensive way to enforce the act. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place. Requiring discrimination victims to rely solely on such a remedy effectively neuters the act. The onus, therefore, is on Congress to create a new coverage formula to restore the Act's most important enforcement mechanism, its preclearance requirement. Moreover, Congress should consider other ways to strengthen enforcement of the Act, including provisions to extend bail-in preclearance, the use of election observers, and notice and transparency requirements, as well as ways to facilitate the enforcement litigation by private parties. With preclearance, you stop the harm before it exists. Without preclearance, the harm exists, and then later you can do something to nullify the law, but the harm's been done, closing the barn door after the horse is out. I thank our witnesses and our members for being here today, and particularly Congressman Sewell for her sponsorship and her long work on this effort, and I look forward to a lively and substantive discussion. And I recognize Mr. Johnson for his opening statement.